know if we have any like volume issues. I tend to be a loud talker, so, but I don't know where the mic is for them. So I'm just gonna kind of talk loudly, so hopefully they can.
Yeah. So we'll go ahead and get started, everyone. Thank you for joining us. We still have some people coming in online. You'll see as you join online, I will mute you as you come in just to eliminate any background noise. We have a pretty full class today. If you have any questions, I recommend writing them down. If you're here in person, you should have a pen and paper. And then, hello, welcome. And then also online, if you want to write them down or enter them into the chat, we will try to address as many as we can towards the end of the presentation, but just to be able to get through the presentation, we will hold all questions until the end. So without further ado, I will hand it over to Geneva, who's going to be presenting for us.
Good afternoon, everybody.
Good afternoon.
Thanks for coming, joining us virtually or in person. Good to see you all. Today we're doing an estate planning workshop. So we're going to talk about estate planning, a little bit about what it is, what are all the documents, who are all the people, and why does any of this matter? Okay. So slide, I guess. Do you want me to just let you know like that? Okay. So a little bit quickly to get started. My name is Geneva Vasquez. I'm an estate planning, estate administration lawyer. So I help plan to die and then help deal with everything that happens after you die. And then we also do business planning as well in our firm. Our firm is Jesson and Rains. We have two locations. So one in the South Park area and one out in Fort Mill. I'm licensed in 5 jurisdictions. So I practice in North Carolina, South Carolina, and some other states that are further away. But as a quick disclaimer, I am a lawyer, but I'm not your lawyer. Right? So everything that we talk about today is going to be for informational purposes. I can only give specific legal advice if we've entered into an agreement to work together specifically. So keep that in mind as we move through. I'm going to be talking about things in really broad generalizations, and we'll do my best to give you some examples throughout the way. But if you need specific legal advice about your family, your information, your assets, you're going to need to talk with a lawyer specifically about your stuff. Okay. Slide. So what is estate planning? People hear this word and they think of a grand estate with, a name sign or something to that effect. That's kind of the connotation. But really, estate planning is for everybody. Everybody, even an 18-year-old really needs an estate plan. We call that young adult planning in our firm. But for every person who's an adult, you need an estate plan. I'm going to talk a little bit about why in just a second here. An estate plan controls who's in charge and how everything gets distributed when you're deceased. It also does a lot for you from a planning perspective for while you're living. So if you're incapacitated, if something happens to you and you can't do things on your own, estate planning also encompasses those things as well as healthcare decisions, right? So I'm going to talk in a lot more detail about all those things in a second. It helps to plan for incapacity, medical emergencies, and also for people with minor children. This is a really, really important part of planning to make sure that if the parents are deceased, there's somebody that's able to legally step in that you've appointed to make sure that the children are protected and cared for by the people that you choose. Okay, so that's a little bit about the overview. What I say is, for all adults, and honestly, it doesn't really matter how much you have. I hear this all the time, like, we don't have that much, or it's super simple. I always say famous last words. If anybody ever tells me it's super simple, that's a famous there. It's not going to be simple. But really, everybody who is over 18 should consider doing an estate plan. Now, why does any of this matter? So whether you have an estate plan or not, you do have an estate plan, right? Most people don't know this. We call it the do nothing plan, right? If you do nothing, you have a plan. It's just whatever the state of North Carolina has set for you or whatever state that you reside in at that time. Okay, so the statutes and the law has prescribed an estate plan for everybody, right? They say this is who's going to be your executor, who has priority. This is how things get paid out. This is who gets all of your stuff, right? The law has already said that. They dictate it. The thing is, you might not like the way that the law is wanting to distribute your stuff. You might not like who the law says is in charge. So that's really what an estate plan is about, right? It's giving you the control, putting the reins back to you and taking it away from the state of North Carolina, wherever you live, right? Do you want us to pause for a second while you guys get settled? Good. Yeah, well, I'm just gonna pause for a quick second to let these people sit down and get caught up with us. So that's the important really context of all of this, is whether you have a legal document or not, you do have a plan. It's just whatever the state has said. Now, we're gonna talk a little bit more about that in a second, but when you execute a state planning document, you take the reins back, you take control. You say who's in charge, you say where everything goes, right? And that's why this is so, so important. Because the laws might not work the way that you want them to work, and it might not give things to the people that you want it to go to. These laws vary state by state, right? So whether you die here in Mecklenburg County or you die in your county, just, however many miles away over on the South Carolina border, different outcome, right? Totally different outcome on the way that works, depending on where you live. And sometimes, the laws are the same state by state, but sometimes the way that this plays out is actually even different county to county, because every county has its own little nuance. So I'm going to talk more about that in a minute when we talk about probate. But what is the critical thing is you should know kind of how your defaults work, right? Because I'm sorry, I lost my train of thought. Because things are not always as simple as, oh, I'm married, everything goes to the spouse. That's actually not what the statute says, right? The statute does not say if you have a spouse, they automatically get everything. It depends on whether you have children, the value. So it is a lot more complicated. And what you need to know for yourself is, what is my default and do I like it, right? If you don't like the default, you got to override it. And that's why you're doing these documents, okay, in the first place. Slide. So let's talk about these key terms here. And they can be confusing because as you look at them, you'll see they're all kind of the same words in different orders, right? In different order and sequence. So first is a will, sometimes also called the last will and testament. People know this word. Everybody knows this word, right? For the most part, a will. Not everybody understands what it actually means. So the will is what directs the distribution of your assets that are subject to probate. I'm going to come back to that in a second, right? And that's where you also are naming your executor. So this is where you say who's in charge. And if you have minor children, that's where you say who the guardians are going to be. That's what you're doing in a will, okay? Now, next document is a power of attorney. Everybody know this word, power of attorney? We've all heard this word. We get a lot of misconceptions about the difference between this and this, will and power of attorney. Power of attorney only does anything for you while you are alive. Okay, so even if you have a power of attorney, you execute it, you put someone in power, the minute you die, gone. Does nothing for you. Power of attorney only exists for while you're living. So what does it do? It lets you appoint somebody to be in charge of doing financial things for you if you cannot do them for yourself while you are alive. The will, you're dead. Power of attorney, you're living. See the difference there? Two separate things, okay? Now, healthcare power of attorney, similar kind of words, right? But this is totally different. This is the person or people that you pick to make healthcare choices for you if you cannot make them for yourself. It has nothing to do with money, right? For the most part, right? So these other things have to do with money and distribution of assets, dealing with banks, all that kind of stuff. Healthcare decision makers, you could have somebody who's very financially irresponsible in this type of role, but if you think that they're going to make the best healthcare choices for you, those are the people that you're putting in that type of role. And that's what that document does for you. Now, a living will, again, confusing because we're talking about the same kind of words here over and over again, right? So let's distinguish what this is. A living will is sometimes also called an advance directive or a desire for natural death. I think that last one is the most helpful, right? It's the easiest to remember. Desire for a natural death. That's the document where you are going to say when you want to be kept alive and not kept alive, artificially, hydration, nutrition, all of these types of things, right? That's where you're making those decisions about whether they are keeping you alive. Okay, it has nothing to do with assets whatsoever. This is in the healthcare bucket. And then a trust. In the context of today's conversation, we're going to talk about a trust as a revocable living trust. There are lots of kind of trusts in the world. Some of them are irrevocable, meaning they can never be changed. There are also trusts that are created under your will after the will is probated. Those are called testamentary trusts. What I'm going to explain today is a little bit about a revocable living trust. Okay, so we're going to get into that a little bit more detail in a second. But basically, assets owned by a revocable living trust avoid probate. What does that mean? I'm going to get there in a second. Okay, slide. So what does a will do and what does a will not do? right? I always say this, and remember this mnemonic, tell your friends, and it helps spread the word. Where there's a will, there's a probate. Where there's a will, there's a probate. Whether you die with a will or without a will, really, will or without a will, you gotta go through the court process if you have a certain amount of assets in your name. Okay, a certain amount of assets that are belong to you individually. Now, I'm gonna talk in a minute about door number 3, like how do you avoid probate, right? But there's big misconceptions about this because people think because they sign the will, they have the will, their family doesn't have to go to court. Not true. Where there's a will, there's a probate. Okay, remember that. Now, what does the will do? It names the person or people who are in charge. This is important because the statute's going to say who they think should be in charge, but maybe you want somebody else. Maybe you want somebody who's not even in your family, right? You want a close friend. You want somebody that you think is really responsible. That's your opportunity to choose who's in charge. Okay, that's what we're doing in the will. We pick who is going to administer the estate through the court process. Next, it says how the probate assets are going to be distributed. I'm going to talk a little bit more about probate in a second. But what the will does, it says everything that I have that has to go through this probate process, this is who I want it to go to, and this is how, right? You get to pick. So again, you get to override the statute and choose where you want everything to be distributed. For those with minor children, that's where you're also giving your testamentary wish about who gets your children. Really important, because if you don't say this, how does the court know, right? If it becomes a free-for-all, you don't get a say in that decision at all. Now, what a will does not do, it does not control joint or beneficiary designated assets. Let me explain what this means. Many people know a TOD, a POD, transfer on death, pay on death. These are words that are thrown around, right? If you have a beneficiary on something, right? This is any kind of asset that you have a beneficiary. So maybe you have a bank account and you wrote, I want this death beneficiary to be Tom, right? Let's use an example. Tom's your death beneficiary. If you have a beneficiary on an asset, the beneficiary governs, not the will. Okay, so the will only controls things that have to go through the court process. If it has another way to transfer, like joint ownership or pay on debt, it doesn't have to go through the will. So I've seen this happen before, right? Where grandma put together a will and she says, everything is going to Jane, right? Everything, my whole estate's going to go to Jane. Meantime, at the bank, she put Tom on the bank account. She put Tom on the retirement account. She put Tom on the life insurance, right? All those things are going according to that beneficiary designation. They're never going through the probate process, right? Which means Jane might not get anything. This is why it's really important to know how things are set up and how they're going to transfer, right? So those beneficiary designations are a really important part of all of this. And then additionally, that's also applicable to joint property with rights of survivorship. So this is most common. We see with a husband and wife, they have a joint bank account, right? Or they have a joint piece of real estate. They own their house jointly. They're both on the title. If it is joint property with rights of survivorship, what that means is one dies, it transfers automatically to the other, right? Now, that happens on the first step. Of course, if both of them are deceased, you probably have to go through probate on the second death, okay? But it's not subject to the will. If it's going through another path, it's not subject to the will. Really important point here, okay? Now, a will can also be updated as long as you're living and competent. So sometimes people get indecision, like they don't want to do it because they're afraid of things that might change in the future. It's never too early to start. Lock in your decisions now, because I'm going to talk about this in the context of incapacity in a second, but if you lose capacity, you can't execute legal documents, and many people wait until it's too late. Okay? Now, what is probate? Let's talk a little bit about probate, and I like to give a real example. Probate is the court process of dying. There are really 3 reasons that probate exists. Number 1 is for the benefit of your creditors. Okay, so it's the public process for maybe somebody that has a medical debt, your credit card, any kind of bill that you owe money on. It's their opportunity to come forward and say, hey, I got to get paid before you start giving out everything to all these other people, right? They owed me this money. Okay, so it is for the benefit of your creditors, this public process. Reason number 1. Number 2 is if you do die with a will, it's the court's opportunity to say, okay, we looked at this will, we determined that it was validly executed, meets all the criteria, we're going to stamp it. This is what's going to control. Now, it decides whether that will is valid. Reason number 2. Reason number 3 is the practical reason that people realize that they have to go through probate. If you die with something in your name, individually, it is only in your name and it has no other way to transfer. So it doesn't have a transfer on death. It doesn't have a joint owner. It's in your name. It gets stuck. It's in your name. So probate is the process to move things out of your name after you die. And here's the reason why, right? You can't close the account. You can't cut the final check or do anything with those assets to sign that if you're dead, right? You can't sign to close the account. So here's a practical example. Husband has an individual account, right? Maybe they had some joint accounts too, but he has an individual account. And wife knows that the account exists. So she goes to the bank and says, bank, my husband's died. I need to get access to the account. I need to get access to the assets. Say, well, you're not a joint owner. You're not a beneficiary. So on what authority are we going to give you access to this account? Says, oh, here's the death certificate. Like, he's dead. On what authority, they say. She's like, oh, we did the wills at the will clinic 5 years ago. I'm named as the executor. Let me go get it. She brings it back to the bank and they're like, on what authority? Because what she's done in this will is she's nominated an executor. The bank is not going to make a decision whether she's the right person or that will is valid, right? So they say, you need a court order to be able to do this. She's like, well, what do I do? Right? She tries to figure out, call some lawyers, goes down to the probate court, right? So now she goes to the Mecklenburg County probate court and figures out what she's got to do. She's got to fill out an application. This is very high level, right? Just to give you an example of how this works. Fills out an application. You've got to say everybody who's involved, all the beneficiaries, if there's a will, if there's no will, what are the assets of the estate, right? You give all this information. You submit this to the court, and then the court is the one that makes a decision whether the will is enforceable and whether she's the executor. To be the executor, you have to meet certain criteria, right? So you have to be competent, you have to not be a felon, there's certain things, right, that they want to evaluate. And sometimes if there's no will, they might require the person who's applying to post what we call a bond, kind of like a bond to make sure that they're not running off with the assets of the estate. Okay, so now you go through all this process. Simultaneously, you're publishing notice to the creditors. Remember the thing I said before about the people that got to get paid? This actually goes in the newspaper. So if you're ever really bored and you want to verify what I'm saying, go through the newspaper and you'll see these notices to creditors, right? And it says the estate is open. This is how you submit a claim if you have a claim. That runs for about a 90-day period where the creditors can come forward. Now that she's the executor, she's got this court order that says that she's in charge. She goes back to the bank and says, bank, here's the thing that you wanted. Great. Okay, we're going to let you sign because remember, the dead person can't sign, right? So we're going to let you sign and close this account. Great. They give her the money and they make out the money. The check is payable to, not her, the estate. Okay. And so what she's got to do is get an EIN number from the federal government, open an estate bank account, put the money in that account. She's publishing the notice to the creditors, and then she's got to go get everything else, right? So that was just one asset, right? You got to do this with every asset that is payable to the state that she can't get out of the person's name, right? So this is what this process looks like, generally speaking. Now, after the creditor claim period is done, we settle any valid debts, we file the final income taxes, pay any claim, anything that needs to be paid, right? And then we can make the distributions. How do we make the distributions? If there's a will, the will governs. It will tell us where everything goes. If there's no will, we look to the statute. That's where the statute is in charge of who's getting what. So if you don't like that, it's really important to have a will to make sure you're saying where you want everything to go. Okay, now that's the probate process generally. It is to transfer things that are in your name individually. Oh, will you go back real quick? 3 things to know about probate, right? It is generally a long process. Even the simplest of estates usually take about a year. In Mecklenburg County now, we're seeing the better part of a year to about 16 months. That is how long it takes. So there's delay, right? All of this is public. Everything about your estate, everybody who's involved, it is all in the public record and it's searchable on the internet, right? We have e-filing system now. You can find anything about all this information, and it can be expensive. On average, we see that that estate administration can be about 3 to 8% of the value of the estate. Okay, so this is just the money to pay for all the expenses involved in administering the estate. If you have a will, you don't get to avoid this process, but you can reduce the friction, right? You can make it a little bit simpler from the appointment of the executor. You can waive those bond premiums. You get to say who's in charge. You get to say how everything's going. So you don't get to avoid this, but you do get to make it more streamlined, which can save some money on the back end. I'm going to do questions at the end if you don't mind. So now we can go to the next slide. So what is a probate asset? What is a non-probate asset? Remember I used the example before about Jane and Tommy, right? The beneficiary designation versus this. So things that go through probate are individually owned assets, only in your name with no beneficiary. In other words, they have no other way to transfer out of your name, right? No other way to transfer. So if you own it alone, you have no beneficiary, no co-owner, it's got to go through that probate process to come out of your name. Now, even if you do have a co-owner, but they die before you, if you're the last one standing, it's still got to come out of your name at the second death, okay? Now, what are non-probate assets? These are assets that do not have to go through that process. These are things that have a beneficiary designation, and as I said before, are jointly owned with a right of survivorship. The right of survivorship designation is important because there are other ways to jointly own things, right? So, for example, you can own a piece of real estate that doesn't have a right of survivorship, meaning it's still got to go through probate at the first step. So it's important to know how those things are set up. If there's a right of survivorship, it will go automatically to the co-owner. So the POD, TOD, that just stands for pay on death, transfer on death. Okay, you see these terms a lot. Now, trust assets. I'm going to talk about trust in a second, but assets that are owned by a trust also do not have to go through probate. So remember, individually owned things that have to get transferred out of your name somehow are what's going through the probate process, and that is what the will governs, right? Beneficiary designations, joint ownership, that will trump the will in some way, okay? Next slide. Now, let's talk a little bit about incapacity planning. So most people think about, estate planning as your design, right? Which is part of it. But really, for most people, there is some period of incapacity before you die, right? You get sick, you get a terminal diagnosis, you get some kind of disease, Alzheimer's, you have an accident, right? Any of these things that would impede your ability to be able to do things for yourself while you are living. Okay, now, I'm going to talk a little bit about the power of attorney in more detail in a second, but in order for you to do any estate planning, any of the things I'm talking about today, you have to be competent. Okay, so we get calls like this all the time. My mom has got advanced dementia. We need to do a power of attorney. It's too late, right? It's too late. So-and-so is in the hospital. We need to do X, Y, and Z. It's too late. This is why now is the best time, because if you are of sound mind, if you are able to clearly make these decisions, even if you do have a medical diagnosis, but if it's not to the point where it's inhibiting your ability to make these choices, this is the best moment. Because when those things escalate, it's off the table. And what do? Right? What happens at that point? If somebody needs to go to the bank for you or sign off on something for you from a financial perspective, the only way they can do that is by going to the court to get the power to do that. All that stuff I just talked about with probate, right? Similar proceedings. Sometimes we call it a living probate. It's called a guardianship, right? So if you have a family member, a loved one that has lost capacity, they can no longer sign legal documents, and you need to do something for them, the way that you get that power is you have to go petition the court, right? You have to have a hearing. There's a judge involved. They send a court-appointed lawyer to your house to look through the cabinets and look at the medical records, much more invasive process. So the power of attorney helps avoid or mitigate all of this to the maximum extent that we can. That's why the power of attorney is so important while you are living. Okay, so this governs things while you're living. Planning ahead helps to preserve the control and minimize court involvement to the maximum extent that we can. So next slide. So this is now the financial power of attorney, sometimes also called the durable power of attorney. Okay, this is who is going to be doing things for you from a financial perspective, kind of like the business operations of your life while you are living. Okay, remember, will, you're deceased, power of attorney, you're living. All those things I said about things that are in your name, that's what this governs. So anything that's in your name while you're alive, the power of attorney will allow them to do that. Okay, it can be banking, real estate, business matters, any of those things. Really, really important for business owners to make sure that they have a power of attorney as well. And a power of attorney can be effective in two ways. So you can say, you know what, I've been married to this person for 35 years. We have everything jointly, full trust and confidence that they're always going to do the right thing related to assets. I want it to be effective right now. As soon as we sign this, I want them to be able to do everything, whether I'm incapacitated or not. Option number one, effective immediately. Option number two, I trust you a lot, but I don't want you to do anything with my assets until I'm incapacitated. Okay, there'll be usually in the document a governing provision on when that's determined, but usually a doctor involved to say that you're incapacitated. If you want that, we call that springing. Means it only springs into effect after that triggering event, after you become incapacitated. Okay, so two separate ways to set that up, right? But in either event, very important to put somebody on this document that you trust at all costs, right? Because they're going to be able to use this to go to the bank, to do everything from a financial perspective for you. So it's a lot of power, a lot of control under this power of attorney document. Now, the agent has a fiduciary duty, which means they have the legal obligation to do the right thing, right? There are certain things in the law that they're supposed to do, and they can be held accountable if they don't. But generally, you want to choose somebody that you really trust to be in this role. And lastly, I said this before, but I'm going to say it again because you'll repeat it to your friends, right? You say, power of attorney goes away when you die. Okay, and we get phone calls all the time with people saying, I'm power of attorney, I need to do the estate. It does nothing. The minute the person has died, the power of attorney is gone. Okay, next slide. So now healthcare planning, I already kind of described these documents. Let's go into this a little bit more detail. So the healthcare power of attorney, it sounds similar, right? But this is your health agent. They don't have to do anything really with money, right? They're not going to the bank. This is the person who's talking to the doctor if you can't talk to the doctor. This is the person who's making decisions. If the doctor's saying, are we giving them surgery? Are we doing this kind of testing? Are we keeping them alive, right? Are we donating their organs? Are we, any of these types of things, right? They're making all those choices if you cannot speak for yourself, right? This could either be you really can't, you're completely incapable of speaking, or just you lose capacity, right? So this is a really important person that you trust to follow through with the decisions the way that you want them to do these things, right? And then the living will I mentioned before is governing when to be kept alive and not be kept alive, okay? A desire for natural death. Both of those two documents, there's a North Carolina statutory version of these. Right. So basically the legislator said, well, we think everybody needs one of these. So we're going to give you a prescribed form that we think meets the criteria. And so those are available. Right. But important to note, there's some formalities in how they need to be executed. So they do need witnesses, notary, all these kind of formalities in the signing to make sure it's valid. But those are pretty available. And if anybody, is in kind of a medical emergency, that's the first thing the doctors are asking for is, does this exist? If you're going in for a procedure or surgery, many times they're asking you have these things before, right? Because they want to make sure if you're on the table and they have to make a game time decision, they know the appropriate person to ask. The risk of you not choosing is that, again, these things fall back to the statutes, right? So if you know who you want to be in these roles, really important that you put it down on paper and make sure that it's legally executed and enforceable for yourself. Okay, and there can be limitations and those types of things. And it doesn't have to be the same person as any other roles. You can put a different people in all of these things. One person's the executor, one's the power of attorney, one's the healthcare agent. They don't have to be the same person. And there's no requirement that they have to be family members either. Next slide, please. So let's talk a little bit about trust, because I know people always have questions about these. It's something that, people hear this term a lot. Like I mentioned, I'm going to be talking about a revocable living trust. Okay, so lots of kind of trust. We're going to focus in a revocable living trust, which is the most foundational planning tool for estate planning for death and incapacity. So it plans for both. Now, assets owned by a trust avoid probate. Let's talk about why. People think of a trust as, some grand thing. Basically, it's a legal document, right? And there are a couple parties to this document, the people who make it, the people who are in charge of the stuff that's in the trust, and the people who benefit from it. For most people, you're all three of those things while you're living, right? You make the trust, you govern the trust, you use the stuff that's in there, right? You use your own bank accounts, all that kind of stuff. This is the reason why a trust works differently than a will. So when you create the trust, you give it a name. This is a critical part. I always use the same example. Let's call our trust the Green Frog Living Trust. Okay, so you come up, you can anything you want, you give it a name. Now what you do is after you create the trust and you sign it, you move all of your assets into the name of the trust or make them payable on death to the trust. So if you own a home, the deed to the property, you do a new deed to retitle the property to the Green Frog Living Trust. Your bank accounts get retitled to the Green Frog Living Trust. Brokerage accounts get retitled to the Green Frog Living Trust. Business interests get assigned to the Green Frog Living Trust. Your personal property gets assigned to the Living Trust, right? And then retirement accounts and life insurance, it's usually a strategic decision, but we will beneficiary designate them on death to the trust, right? In most instances, kind of case by case analysis on the retirement accounts, but life insurance, we usually put with the trust, right? On death. Now, when you die and they say, okay, let's go figure out what was in their name. Nothing in your name, right? Remember the reason I said you had to go through probate was to get it out of your name? Now it's all in the name of the trust. And what the trust says is when I die or I become incapacitated, I want Tommy to step in and manage all this stuff and give her everything to Jane, right? That's how you structure it. So that person that steps in, we call that your successor trustee. They manage. And most trusts will trigger to say when you die, but also if you become incapacitated, they can manage all this stuff for you as well under the trust. And then your beneficiaries under their work, kind of similar to how you think of as a will, right? You're saying, well, you want to get what? Okay, so that's the difference between a will and a trust. So if there's nothing in your name, it doesn't have to go to the probate process to come out of your name. It's not subject to that process. So assets owned by a trust are exempt from probate. Again, it gives a little bit more control. There are a few people that are better candidate for trust. Usually, I get this question a lot, like, do you have to have a certain amount of money to have a trust? No, that's not really what we're looking for. It's not a dollar amount, because sometimes people they have one adult beneficiary, everything is going to them. It's really simple. They don't have anything that's subject to probate. They don't really need a trust, even if it's a lot of money, right? So it's an analysis. It's if you want to stay out of probate, first of all, most people choose to use a trust because they don't want their family to have to go through that process that I just described, the probate proceeding, number one. Number two is it's a good fit for blended families, right? So a lot of time where we have complexities in second marriages, children, things like that, right? Good fit there. Business owners, it's a good fit. And a lot of times property owners, people who own a home, right, are a good fit for that, because it frees up them having to go through that court process and be able to distribute the real estate in a quicker fashion. Also, I just want to note this. If there are minor children involved as beneficiaries, so anybody under 18 that's a beneficiary, they sometimes can be a better fit for a trust because it reduces court involvement and the delay in distribution of assets to them. But where you might have a special needs beneficiary, there's a lot of additional specific planning that needs to be done there. Okay, that's kind of beyond the scope of this presentation, but I just want to mention that because if you have somebody that has a special needs diagnosis, and because of that diagnosis, they're eligible for Medicaid or Social Security based on the diagnosis. If you put their name on a beneficiary form, or you put them just directly inheriting under the will without specific guardrails, it could eliminate their eligibility of getting those benefits, right? So special needs beneficiaries need special planning, and that's really a more advanced planning. Full candidates is going to cost more money and time to do all that, right? But it's frequently very worth the value to try to protect those individuals. Okay, so I just wanted to say that. Now, trust administration. You still got to do some stuff with the trust after you die. You don't have to go through that court process. It typically saves time, usually faster. It typically saves money. So on average, we see trust administration is about 1 to 3% of the value of the estate. Remember, I said estate administration is about 3 to 8%. So it can be a significant savings on the back end from a cost perspective. And it also is private. That's what a lot of people like about it, right? So even if your beneficiaries are not receiving huge, large sums of money, most people don't necessarily want the world to know what your kids are getting, right? So that's a big driver. But what I'll say about this is trusts are more expensive and they're a bigger time commitment. So for many people, if they're choosing between these things and it's like, well, I want to have a trust, but they have nothing, I always say a will is better, right? Phase it. It's better to have something than to have nothing, right? To wait long enough until you're getting into the trust. You can always transition into that type of plan down the road. If you have nothing and trust is inaccessible to you, start with a will-based plan because that's better than having no control at all, right? Okay, let's go to the next slide here. So I've already mentioned this, what happens without a will, right? Things are going to go according to the state law, your beneficiary designations. Again, specific carve out for the minors here. Anybody you know that has minor kids that does not have a will, you be the sounding charge for them and say, you got to get this done. Because if something happens to them, I mean, you hear these stories all the time, right? And we see them. It's like there was a single parent and then they died. And it's like, who's gonna take the child? The parent gets no control over that, right? It's really, really important to have this documented we're really, really passionate in our firm about making sure that minor kiddos are protected. And so I just spread that word to anybody that you know, but that's one of the big things that a will does. And all these other things I've already mentioned. So we can go to the next slide. This stuff has real impact on families. I mean, we deal with a lot of phone calls from people who are like in the first, week at post death, and they just literally don't even know where to start, right? What is the first thing that I do? I'm going to talk about some action steps in a second, but if you have no plan, you have nothing, it increases court involvement, it increases expenses, it increases time delay, and you get no say, right? You have no say in how any of this actually works. Where we have minors that are going to have inheritance, if there's not specific planning for how they're going to receive that, the court could potentially be in charge of that money for the entire time until the child is an adult, right? There's oversight on this. So again, where there's minors involved, specific planning needed. I also want to mention this about young beneficiaries, right? So sometimes people will put their 18-year-old kid on a beneficiary form, right? TOD, your retirement account, whatever. Important to think about that too, because remember what I said, that beneficiary form governs. So if you die, you have an 18-year-old that is about to receive a $500,000 life insurance policy, just using a large number to illustrate this, right? That's going directly to them. Mm-hmm. But there's no safeguards. It goes to them, to their bank account. You make a decision about how quickly you think that's going to be gone, right? But if you do some additional planning mechanisms, there are ways to kind of route that to be more protective. So, beneficiary forms are a good tool, but they are not the only tool, right? So it's important to really consider all the context and the relationships and the people that are involved there. And I do want to mention this too. I don't know if I have it on the next slide, but related to that, we never ever recommend that you put a minor on any of those beneficiaries, right? On any of those beneficiary forms. It's subjective to the court process anyway. Minors can't own things. Can't own anything in your name until you're 18. So it convolutes it. And I will asterisk this as well. The workaround is not to put another family member. Okay, so I see this all the time. Like, oh, well, we have this life insurance policy through work and we want it to go to our child, but we know that they're a minor. If I die, I'm just going to put my mom's name on there, right? Or my aunt or some other trusted family member, because I know that they'll do the right thing and distribute it to the child. Do not do that, okay? The reason why is even if they do the right thing, even if they don't do anything wrong at all, you give it to your mom outlives you by 5 years, she dies. How is that distributing now? According to her estate, because you gave it to her. It's her asset, right? Not only is it going according to her estate, but she doesn't have to give your kid a dime. There's no legal obligation to do this. Now, most people are not putting somebody on there that they don't think would do that, but money makes people do crazy things, right? Everybody knows that, right? So I don't ever recommend doing that. And we can go to the next slide here. So before you start planning, so one of the things that I was charged to do is to give, this context, this baseline information before one of the upcoming will clinics that's happening. So I'm going to talk a little bit about that, but whether you work with a will clinic, you work with a lawyer, there are a few things that you want to think about before you kind of start this process. Number one, I already said it's never too early to start, right? That's the most important thing. But you want to start thinking about people that are going to be involved. So I just explained some of these roles. Start to think about people you trust, what their skill sets are, all of these types of things. Identify that. Think about family dynamics. When I meet with my clients, we spend a lot of time talking about the family drama because everybody's got it. Sometimes I got to ask a lot of questions to figure out where the potential landmines are. But you got to think about how all this is going to play out, right? Because these planning documents help to mitigate those things on the back end. They help to reduce that if you do this correctly. And then what are your goals, right? Who are you trying to leave things to? How do you want to leave it? What are your big underarching goals there? And think about, how the assets are going to be distributed. So with that, also action item is to start organizing your basic asset information. Before you talk to anybody about this, it's really helpful to have a list, right? Even if you don't have a ton of assets, still you should know what they are, where they're located, and how are they set up. So are they in one name? Are they in two names? Or is there a beneficiary on there? Because remember what I said, if you have everything that's set up that's not going to go through the will, you got to think about if that's what you really want to happen, right? So listing this down is a really important first step, is to just know what you have. Okay, and the next slide. So your key roles before you meet with a lawyer or in the will clinic, whoever you're meeting with there, think about what I said, an executor or trustee. The skill set we're looking for there, I don't need them to be a financial planner. They don't have to be a lawyer, but the soft skills that we're looking for is they're really organized. They are persistent. This is the person that will sit on hold for 6 hours with Bank of America if they need to, right? And then if they lose the call, they're going to call back. That's the skill set we're looking for in an executor. They have good follow through and they're making sure that the I's are dotted and the T's are crossed. Your power of attorney, again, you want somebody who's responsible, but this is somebody that you really trust to have access to your bank accounts while you're living, right? To be able to do all these things for you. You got to make sure it's somebody that you really have a lot of confidence is never going to do the wrong thing for you. Your healthcare agents, who is going to make these healthcare decisions in the way that you would want them to be made? Maybe it's somebody you really trust. I mean, I hear this all the time, like, oh, I know my mom would be a great agent, but she would never let me go, right? Or the opposite, like, oh, they're not going to give me a fighting chance, right? You got to think about who's going to make these wishes consistent with what you would want as the outcome and follow what you put on paper, right? And then the guardian, obviously, I mentioned this for minor children. This is who's stepping into your shoes as a parent, who is going to do all the things related to your child. Really important role. Next slide. And then for your distribution planning, so let's quickly talk about kind of the structure. Under will or under trust, this is applicable either way. Once we have the pot of everything that's got to come out, right? We're going to give away whatever is going through the will or going through the trust. A few different types of gifts categories. There's the specific gifts. I always say these are the off the top. Okay, so if you say, oh, I got whatever's here and this is going to my 2 kids, like, oh, I really like to leave, that thing, that piece of jewelry to Tammy. I'd really like to leave, $1,000 to my Habitat for Humanity, right? Wherever you want to leave these gifts, these off the top things, right? You kind of itemize those. Those are what we call specific distributions. Then the residuary is the pot of whatever's left. How will that be broken up? For many people that have children, it's like, kids, whatever, however you're going to divide that. But I mean, we just wrote a blog about this last week. Lots of people don't have children. So you can divide this up however you want. Or even if you have kids, you don't have to leave them anything. You can give it to whoever you want, right? You're choosing who those residuary beneficiaries are. And then the contingency planning. So if that person dies, where does it go next? Right? You got the backstop. That is one thing I'll say that beneficiary designations don't do with great extent. You can't do multiple layers, right? As many layers as we can do with a will or trust. And then the remote contingent, I always call this the nuclear option, right? If everybody that you've listed in your plan is deceased, where do you want everything to go? Right? A lot of times people are choosing extended family members or friends that they like, organizations, things like that, right? And then, again, a big part of the distribution planning are these beneficiary designations and the rights to survivorship, right? So that's also part of all this structure. Next slide. So your action items. What are you going to do before you start your estate planning? Number one, list all the assets in one place, how they're owned, who are the beneficiaries. Know that, right? Very important. Again, identify the ownership and then confirm those beneficiary designations. And again, special consideration is if you see you're opening up your account, like, oh, I got minors on these things, not a good idea, right? You got to have further conversation about that. Okay, and then next. And the goal of all of this, why are we doing any of this? Give you clarity in your decision, puts you back in the driver's seat of the outcomes of all of this stuff. You get to be in charge and take control, protecting your family, peace of mind. I always say, do everything you can to try to keep your family out of court conflict, right? Most people at the end of the day, you don't want your family to fall apart over the armoire or whatever it is, right? And so having these things documented can mitigate those issues. Peace of mind for you. Next slide. So floor is open. I know we had one question before. Do you still remember it? Maybe
I have a bunch of questions.
Maybe I answered it.
But I don't remember the first one. So in the example, you said you were currently revocable or was it irrevocable?
Revocable. Who can change it?
Okay, so irrevocable.
Irrevocable, can't change.
Okay, so the revocable living trust with this. So let me make sure. Is North Carolina a state where, let's say, I can't take care of my mom and she has to go on assisted living? Is North Carolina going to try to take her property to pay for it?
So I thought some questions might come up related